Think about those quirky local laws you hear about, like not being able to have a donkey in your bathtub or banning purple houses. They sound funny, but do they always stand up to bigger rules? No, state statutes do not automatically govern over all local ordinances in every situation. While state law generally holds a higher position in the legal hierarchy, there are specific principles that determine when a local ordinance must give way to a state statute. This hierarchy is primarily determined by a legal concept called preemption. Preemption means that a higher level of government's law takes precedence over a lower level's law when there is a conflict. States can explicitly state in their laws that they intend to preempt local regulation on a particular topic. This is called express preemption. For example, a state might pass a law regulating gun sales statewide, and specifically say that no local government can create its own gun laws. Sometimes, preemption is implied. This happens when a state law is so comprehensive on a particular subject that it's clear the state intends to occupy the entire field, leaving no room for local governments to regulate. This is often seen in complex areas like environmental protection or utility regulation. Another important factor is whether a state follows Dillon's rule or grants home rule. In states that follow Dillon's rule, local governments only have the powers explicitly granted to them by the state, or those necessarily implied by those grants. This means local ordinances are very limited and easily preempted. Conversely, in home rule states, local governments have a broader authority to govern their own affairs, as long as their ordinances do not directly conflict with state law or a subject where the state has clearly intended to preempt. So, a local ordinance on something like pet licensing or local parking rules would generally be fine unless the state has a very specific and conflicting law on that exact topic. To figure out if a state statute overrides a local ordinance, you first need to identify both the specific state law and local ordinance in question. Then, you examine whether the state law explicitly states an intent to preempt local action. If not, look for implied preemption by assessing how thoroughly the state law covers the subject. Finally, consider if your state operates under Dillon's rule or home rule, which influences the default power balance. When in doubt, research your state's specific preemption laws and local government powers. This interplay between state and local laws is a fascinating aspect of American jurisprudence, designed to balance local needs with broader state interests. Understanding concepts like field preemption or conflict preemption gives you an insider's view into how our legal system handles these jurisdictional questions. For instance, conflict preemption occurs when compliance with both the state law and the local ordinance is impossible, or when the local ordinance thwarts the purpose of the state law. It's not just about one being bigger, but about careful legal interpretation of legislative intent. Knowing these distinctions helps you understand why some quirky local laws remain as valid, while others might be easily challenged. It reveals that the power of your city council or town board isn't limitless but is carefully defined by state authority. This framework ensures a degree of consistency across a state while still allowing local communities to address their unique needs and challenges.